Welcome to Navigating Exempt versus Non-Exempt Classifications, a guide for attorneys. I'm Lorena Vasquez, Vice Chair of the Beverly Hills Bar Association's Employment Law Section. I'm delighted to introduce today's speakers, Clifton Albright Sr. and Clifton Albright Jr. Clifton Albright Sr. is founding partner and the president of Albright, Heyen Schmidt, APC. He has an AV preeminent rating from Martindale-Hubbell. He is an active trial attorney. Mr. Albright specializes in providing legal representation for employment, labor, and tort defense of governmental and private entities. He has been involved in numerous state and federal jury trials from start to verdict. He also has a successful appellate record. Mr. Albright oversees the firm's litigation, negotiation, business transactions, and conducts employment investigations and Fair Labor Standards Act compliance audits. Clifton Albright Jr. is a partner at Albright, Heyen Schmidt. He is a member of the firm's employment litigation team, handling litigation in all stages from inception through jury trials. His practice includes general and complex business litigation and labor and employment matters. Clifton often conducts employment investigations pertaining to discrimination, harassment, retaliation, and wage and hour claims. While attending law school, he was a member of the nationally ranked Bryan Trial Advocacy, which is currently ranked 4th in the nation. He also clerked for the Honorable Carol Rose in the Los Angeles County Superior Court. And now, let's get started.
Perfect. Good morning, everyone. As Lorena just let everyone know, my name is Clifton Albright Jr., and this is my son here, Clifton Albright Sr. And we are attorneys here at Albright, Heyen Schmidt, and it is absolutely a pleasure to be presenting to you. I wish I could see your faces, but happy that you can see mine. So at least I feel like we're friends a little bit. But Shirley, thank you for joining us today. We're here to delve into one of the most complex yet crucial areas of employment law for businesses operating in California. That's the proper classification of employees as either exempt or non-exempt. Getting this right is absolutely critical for compliance and for mitigating significant legal risks. And then can we go to the next slide? So we're going to be here for a while, so I wanted to give you a roadmap so you know kind of where we're going. We'll begin by discussing the high stakes involved in employee classifications and why it's such a critical issue for employers and attorneys who advise them. Then we'll cover the legal framework, focusing on the key differences between California and federal standards. And to no one's surprise here, the federal standard is going to be what's essentially the floor. California is going to be the ceiling. We'll define the baseline by outlining the robust rights of non-exempt employees, which is the default status in California. And we'll go over that a bunch, but I'll say it here, I'll say it a few more times. The standard in California is that employees are presumed to be non-exempt. And from there, we'll go into the two-part test, which is how we test for to see if an employee is exempt or if they fit the standard or the default of non-exempt. Finally, we'll cover the significant risks of getting it wrong and provide some practical best practices for compliance before opening up to questions from you guys. And then can we go to the next slide? Okay. It's so weird doing this where I'm just talking to a screen, but it's okay. We'll do this. So let's begin by emphasizing the gravity of this issue. So employee misclassification is a very common it's a very common problem that happens to essentially all employers across all industries. It's simply because a manager or an employee holds the title of manager, that does not mean that they themselves are exempt. And we'll go through the exemptions, which exemptions apply in those situations in a little bit. But employment misclassification is not a minor administrative oversight. It is, in fact, one of the most common and costly mistakes that California employers can make. For example, as you all know, in California, employees have the right to go back 4 years and collect 4 years worth of meal and rest break violations, or missed meal and rest breaks, and all other wage and hour type of issues. And so that adds up very quickly. And especially when you get into a situation where you're in a class action, you have multiple plaintiffs in a particular case, those fees add up and they multiply very quickly.
Yeah, and let me just add, JR, with one of the things that you really need to be careful with overtime and meal breaks is that it's the employer's responsibility to make sure that the employees don't have overtime, and if they do have overtime, it's the employer's responsibility to pay them the overtime. And with regard to meal and rest breaks, if it's the employer's responsibility to make sure that the employee takes their meal and rest breaks during the proper time. And all the employee has to do is say, I didn't get it. And then it shifts to the employer to prove that they did. And a lot of employers don't keep records. And if you don't have a record of it, it didn't happen. So, and the penalties are substantial. And like JR just said, they can go back quite a ways. And not only can they go back for a particular employee, they can go back for groups of employees, and the waiting time and penalties apply. So just wanted to let you know that these are significant in California. In California, the employee is presumed correct, and it's up to the employer to show that the employee is incorrect and did get all the particular benefits that they were supposed to receive as employees. Go ahead, Jim.
Yeah, absolutely correct. And, and this is, and I'm repeating it for the second time, I'm probably going to repeat it about 10 times. And that is that the legal presumption in California is that every employee is non-exempt unless proven otherwise. And yes, unless proven otherwise. All right, can we go to the next slide? So, before we start talking about what the exemptions are and how to classify which employee qualifies as non-exempt versus exempt, it's important to understand what rule of law that we're dealing with. And in California, we're obviously going to be dealing with California state law, but we also have federal law. Now, federal law is going to be the FLSA, the Fair Labor Standards Act, which sets the baseline for labor standards across the nation. And as you all know, California has a stricter requirement and is more generous towards employees. And so where there is a conflict between the federal labor standards and California state law, you're to go with the law that is more protective of the employee. In California law, we have the California Labor Code as well as the IWC wage orders, and they provide what is the ceiling. The key principle for your clients is simple. If federal law and state law conflict on a particular issue, go with the one that protects the employee more.
And that's always going to be California law. California is very heavily employee favored, and so employers are well advised to figure out the California law and make sure you're in compliance, because if you're in compliance with California law, generally you're going to be in compliance with federal law.
Yeah, absolutely. And can we go to the next slide? So before we get into the specifics, let's just go over what when overtime pay is applicable, when meal and rest periods are applicable. For overtime pay, There's nothing special. It's the same as it's always been, which is you are paid for 1.5 times your regular rate of pay for any more than 8 hours worked in a day or more than 40 hours worked in a week. And then that's for consecutive days. And on that 7th day, as you know, employers are required to pay double pay for any hours worked on a 7th day, or for any hours worked in excess of 12 on any particular day. For meal periods, employees are entitled to an unpaid 30-minute rest break for all shifts over 5 hours. It is for over 5 hours. If a shift is 5 hours, you may not need to provide that rest break. And there is a paid rest break, which is for a paid 10-minute rest break for every 4 hours. Work. The reporting time pay. The reporting time pay is for when an employee is called into work but is essentially sent home and not required to perform any work. Typically, the employer is required to pay at least half of that day's wages, or the equivalent of 2 hours. So now we get to the exempt status and how to classify. For the most part, all employees are going to be considered non-exempt. And there are few exceptions where they are exempt. But the test to determine whether an employee is considered exempt, it's a 2-part test. The first is the salary basis test, which is essentially going to be, does this employee meet California's, or make more than twice California's minimum wage for full-time pay? Part 2 is going to be the duties test, which is going to analyze what specific tasks a particular individual performs on a day-to-day basis. There's going to be some differences we'll discuss with federal law and California law when it comes to the duties test. Federal law looks more so at what the person's job description says they do. And it just looks at what does it say that this individual's most important functions are on paper, whereas California looks and says, what do you actually do in a day, not just what's on your job description. So federal is qualitative, California quantitative, and we'll get into that a little bit.
Yeah, and you're going to have the same penalties. You may meet a federal test. You may meet the federal test by, describing what you have the employee doing. But when you get to the state test for California, they're going to be looking at exactly what the particular job functions are, is this person a supervisor? Is he supervising 2 or more people? And what percentage of his workday is doing things that require his judgment as opposed to what the employer tells him to do.
Mm-hmm. Exactly. And, the discretion, exercise of discretion is absolutely huge when it comes to the duties test. Every exception we go through, one of the questions that's asked is, does this individual have discretion outside, and are they not being supervised on their normal routine decisions? Okay. So, what just happened? So part 1 is this is going to be the first test, which is meeting California's minimum pay requirement. So the rule is very clear. An employee's monthly salary must be at least 2 times the state's minimum wage for full-time employment. To illustrate this point with 2025 figures, California's minimum wage currently is $16.50. And so I just want to take a quick pause here. The requirement is California state's minimum wage, not the local jurisdiction or what that industry's set minimum wage is. So it's always going to be California state minimum wage. In fast food, we don't go and say it has to be double the $20 minimum wage. We just stick with California state minimum wage, which is $16.50. So the calculation is $16.50 multiplied by 2, so I'll give you double, multiplied by 40 hours a week, a full work week, multiplied by 52 weeks per year, which gives you an annual salary of $68,640 per year. So this amount will increase anytime that the state's minimum wage goes up. So it has to be checked on an annual basis, or whenever the state's minimum wage is changed, this salary test is updated, and this salary test is updated.
And just bear in mind that this is only one test of a multiple test determination, because some employers, oh, he's making $70,000 a year. It still may be non-exempt. So don't use this as your only marker in terms of whether the employee is exempt or non-exempt.
Absolutely. And when it comes to the person's salary, it's also important that the $68,640 that they receive at least is a set salary. And that doesn't include what they make if they have a salary plus commission. This has to be just strictly salary. No matter what they do, they're making at least $68,640 per year. And there are some permissible deductions when it comes to quantifying the step one. California generally follows federal rules. Employers can make deductions for full day absences due to personal reasons or for sickness if there's a bona fide wage replacement plan. So deductions are also allowed for leave taken under FMLA or CFRA for major safety rule infractions, or for legally required withholdings like taxes. However, improper deductions can jeopardize an exempt status. So it's very important that you instruct your clients to be certain about which deductions they're making and why. This brings us to part 2, to the second test, which essentially is the California duties test, or the 50% rule. So we're going to talk about quite a few different exemptions that do apply in California, but the one thing that is consistent between all of them, besides having to meet the first test, is that discretion, managerial tasks or management tasks have to account for more than 50% of the work being performed. So an employee must spend more than 50% of their work time performing duties that explicitly qualify for this exemption. This is a major difference from the federal FLSA standard that we previously talked about, that simply asks, are the primary job functions that you perform, the most important things you do, are they considered exempt? Are those tasks exempt? In California, the emphasis is always actually on tasks performed, not job titles or descriptions. So what's on paper doesn't count if it doesn't reflect reality. And there's a case that I cite here at the bottom, Heyen v. Safeway, which, to keep it short, the court found that store managers who spent most of their time on non-exempt tasks like stocking shelves and working a register were not in fact non-exempt, despite their title and apparent managerial authority. Perfect. So let's move into the specific duties for our first common exception. That's going to be the executive exemption. And this is going to apply to your department heads and business leaders. And so to qualify as an exempt executive, an employee must spend more than 50% of their work time on duties that include managing a department, customarily and regularly directing the work of 2 or more employees, or the equivalent, which is interesting. So the work of two or more, the work of the equivalent of two or more. So that can be one full-time employee and two part-time employees. That would count for two full-time employees or two employees. Third, having the authority to fire or hire people, and if they aren't able to hire and fire, their opinion and their input is considered strongly by the deciding person in management. And finally, customer. Yeah.
Just clarify that when
Sure.
you have a manager who has the ability to terminate someone's employee or make a decision to hire, that goes heavily towards whether or not that person is a manager and
Correct.
and would be exempt. If the person does not have that ability, if they only are making suggestions to management, that would probably not qualify as someone who has managerial authority. And it's questions, I know you've all had situations where there is a person who, when their opinion comes out, they make the decision, and pretty much that's going to be what's going to happen. That's when he says significant weight. That's what that means.
Absolutely. And so, some of the case law when discussing what it means to have a particular weight, it goes to the level of the employee to which a termination decision is being made. So lower, so if you have a department head who wants to fire someone in, the lower tier of their department, they have the authority to do that. But if they were to wanting to make a decision to hire or to fire someone directly below them, and they needed managerial approval or a supervisor's approval, then their input would be considered heavily. And if it's considered heavily under California's test, it may apply for an exempt. And did we touch on this last one yet?
Yes.
Okay. Got it. So next we have the administrative exception. And unfortunately, this is the one exception that most business owners get wrong. To qualify under the administrative exception, the employee needs to spend more than 50% of their times, including performing office or non-manual work that is related to the management policies or general business practices of the or business operations of the employer. So this isn't someone who is helping with sales. It's not someone who's selling outside of the company. This is someone more so helping the company itself function and enforcing policies. So an example for this one that I found that I really liked was an HR manager. An HR manager who is responsible for implementing and developing policies for a company would be considered exempt, given those tasks. But an HR administrator who is only processing vacation time or something like that, they would not be considered exempt.
Yeah, and when we talk about exempt versus non-exempt, it's pretty important that you understand why this makes a difference. And the reason it makes a difference, because if an employee is exempt, they can work all day and all night, no lunch, no overtime pay. They don't get any of that. And so every employer wants everybody to be exempt so they can work them as many hours as they want without paying them. But if they're exempt, which is if they're non-exempt, that means that anytime they hit that 8-hour mark, they gotta get more money. And if they have worked 4 hours, then you gotta give them that break. You don't have to give a break to an exempt person. At 5 hours, they have to get the 30-minute lunch break, and they have to get it without any responsibilities, without anybody calling their phone, talking to them, walking in the break room, talking to them, because if you do, they get to start all over again. So that's non-exempt. You can sit right next to an exempt person and talk to them right through lunch, and it's no big deal. So that's why you need, so you really need to understand the difference and why it makes a difference if somebody's exempt or non-exempt. And so I thought I wanted to make sure those of you who are on this call have a clear understanding of why it makes a difference when a person wants to be, or the government is qualifying someone as exempt or non-exempt. It's just not the penalties that are so important. It's that the government, if they do determine a person is non-exempt and you've been treating them as exempt, then there's going to be a lot of consequences to that for the employer, and the monetary compensation is going to be significant. And if you go over a certain level, then you reach into another category of the law, and JR will talk about that coming up. Okay,
Yeah.
JR, go ahead.
Okay, and I see we have some questions in the chat. What do we have here?
Why don't you wait until you finish your outline, and then you can go back to the questions.
Understood, no problem. Let's see. So we just finished talking about the business exception. Now we're going to go to the one that applies to us as lawyers, and that's going to be the learned or artistic, the artistic exemption, and also known commonly as the professional exemption. And so, to qualify, an employee must spend more than 50% of their time on exempt duties and fit into one of two paths. Either be a licensed/certified professional or a learned professional. And I'll go through those right now. So a licensed certified professional is going to cover someone who is licensed by the state of California in the professions such as law, medicine, dentistry, optometry, architecture, engineering, teaching, and accounting. While pharmacists are given a special carve out here, pharmacists and registered nurses are generally excluded as exempt employees unless they specifically meet the exempt criteria. So nurses although it says medicine, nurses are not always considered to be exempt employees.
What about paralegals?
Paralegals are not considered exempt. Yeah, unfortunately. Learned professionals. Learned professionals, this is going to be someone who has an advanced degree. Typically, this is in science, where you have someone who's a PhD and they are essentially just in a lab doing research, and they're in a very highly specialized field, and they're researching something that is very unique and requires someone of their experience, and intelligence. So the learned professional is often a lesser used criteria, but it is available. There's also the artistic professional, which is going to apply mostly to musicians, and all types of artists, whether it be someone who paints or whatever it is that they do. And under the artistic professional is actually where paralegals are specifically designated as not being an exempt professional. So it'll be journalists, news writers, and paralegals are all considered non-exempt employees under the artistic professional standard exemption. So There are three others. These are lesser disputed. The computer software exemption. So this actually has a different criteria for how it evaluates what the standard pay for a computer software exemption is at $56.97, which is a lot more than the $33 that is normally required for the other exemptions. So a computer specialist, this applies to skilled computer professionals. They must be engaged in duties like applying systems analysis techniques or designing, developing, and analyzing computer systems or programs, stuff I could never do. Outside sales exception. This is actually probably the most straightforward one. All it requires is that the individual is 18 years old, spends 50% of their time or more outside of the place of business in the act of selling while they're selling or servicing customers of the business. And then lastly, there is no salary test. So do you spend more than 50% of your time outside of the business? And are you at least 18? And there's actually one more I just remembered. This is a commission-based. The majority of your commissions, of your pay, comes from commissions. Lastly, we have commissioned inside sales. And this is limited to the industries governed by IWC Order 4 and 7. And if you don't know what those are, that's okay, I got you. IWC 4 is going to be the professional, technical, and mechanical fields, whereas IWC 7 is basically think merchants, retail, wholesale, and warehouses. That is IWC 7. For them, they require that an employee must earn 1.5 times the state minimum wage, less than the double, 2 times the minimum wage for the others. And more than 50% of their commission must come from, of their compensation must come from commissions. And also there has to be a written agreement, for the payment, for payment. Yeah. Okay. The financial repercussions of misclassification are severe. Unfortunately, if an employee is misclassified, that opens up a company to potentially 4 years of back pay for unpaid meal, rest, and lunch. So it's important to continually audit your own staff and make sure that your job descriptions are up to date, and that everyone who is being classified as exempt truly is exempt.
Yeah, and just as an example with regard to that and the, the payment of wages and properly classifying employees, we had a situation where one employee complained that they weren't being paid properly. And the lawyer that they went around and gathered up a bunch of employees, and the employer didn't have the records that they should have had. This one employee was said that he was owed $200. By the time that they got the other employees, and the employer didn't have the proper documentation of rest and meal breaks and overtime, the actual penalties and liability to the company came out to about $3.5 million. They had quite a few employees. We were able to negotiate it down to about $650,000. But this all came from one employee complaining, and when they had to produce all the records, and that did not include the attorney's fees that they had to pay us. So it's really important, because you might be dealing with one employee, but with PAGA, and now PAGA has changed. We were dealing with the previous PAGA, but and PAGA is Private Attorney General Act. And it allows an attorney to act as though the attorney general and on behalf of the state. And so they can get groups of employees. So it's just very important that you are cognizant of what the penalties and exposure is for making a mistake.
Absolutely. Absolutely. And you know, like you said, those penalties, they add, then they multiply because more people get involved, and it just becomes a big issue. So one of the other penalties that actually happens is from waiting time penalties. And so waiting time penalties are assessed up to 30 days of waiting time penalties for every violation that is found to have occurred. And that accounts for each and every violation. So that adds up insanely. The litigation exposure, beyond direct penalties, misclassification is a primary driver for class action lawsuits and PAGA, like my dad was just saying. And it can truly lead to massive, massive penalties. The court in Rodriguez v. Parivar, I hope I'm saying that right, in Parivar made that very clear, because what they found is that despite the management claiming that they believed that their employees were exempt, they weren't. And the court basically said it's your responsibility to make sure your employees are properly classified, and they were hit with a fairly large judgment. So what can an employer do to mitigate these risks? Well, proactive diligence is absolutely key. Getting ahead of the issues before they occur, making sure that your policies are up to date, making sure that the job description that you provide your employees actually matches the job duties that employees actually have. The audit should involve detailed questionnaires where employees and their managers document actual time spent. And this is the big issue that a lot of management will have, is specifically with these questionnaires. It's because management is going to want an employee to be working on A, B, and C, but if the day actually requires that the employee work on D, E, and F, it becomes an issue. Management's expectations and the realities of what the employees on the ground are experiencing, they differ. And that's where we get into this issue of misclassification. So I can imagine that some of you might be asking, like, okay, so why is it so difficult for employers to have proper classification for their employees? And the answer is actually fairly simple. Things change. As individuals grow within companies, they assume more responsibility. Job descriptions are not updated, and they may shift around from different location to different location. Their duties may change, and so a company may be acting in good faith by classifying someone as exempt when they're truly non-exempt. So it's not necessarily like a reckless disregard for proper auditing of employee services that often lead to these problems. A lot of times it's honestly, like many other things, just honest mistakes. And so I just thought I'd throw that out there.
Yeah, and the determination is arbitrary, because a judge has to decide whether or not the duties that this particular employee are performing are actually considered managerial, because there's no bright line that, like it's A4. If it's A4, then it's fine. But if it's A7, it's not. I mean, those are clear standards, right? But the arbitrator or the judge has to look at the task performed and make a decision as to whether or not these are exempt duties based on case law, but it's still his opinion or her opinion as to whether or not those duties constitute exempt or non-exempt. And of course, you can always challenge it, but it's going to cost a lot.
Yeah.
Which, appeals are very expensive.
Very, very expensive. Yeah. Okay. So,
yeah, I just want to remind you, you got 20 minutes. So you want to get some question and answer then, so I'm not interrupting you.
No, we're near the end here. I think we only have about 2 slides left. Just check in. Okay. And so we've talked about conducting regular job duty audits, and also maintaining accurate job descriptions that reflect reality, not aspirations. And, this goes back to management, what management thinks employees should be doing versus what the job actually requires. Training managers. Managers are on the front line of every organization. They must understand what meal and rest break requirements are applicable and what constitutes hours worked, particularly regarding off-the-clock work. And this also comes into play with having a good HR department or legal counsel that's advising you on what job functions actually qualify as truly managerial tasks. And lastly, when in doubt, classifying an employee as non-exempt. That, when in doubt, it's always cheaper to obtain legal advice on the front end than it is to defend a lawsuit. It's always going to be cheaper to call your lawyer, to have your client call you, than for your client to call you once they have a lawsuit on their desk. Just have them call when they have a question. And then lastly, first, remember that the exempt status is truly the exception, not the rule. And so when in doubt, non-exempt them out, okay? Second, the more than 50% duties test and the twice the minimum wage salary test are non-negotiable pillars of the compliant classification. If the test doesn't fit, you must classify them as non-exempt. Third, meticulous documentation of your classification analysis is the best defense against future claims. Make sure you know what your employees are doing. Make sure you know what it is that they're actually doing, not just what you want them to be doing. And finally, this area of law is incredibly dynamic. There's new legislation and court decisions constantly shaping interpretations and changing the legal landscape of how we interpret exemptions. So it's important to stay up to date and to make sure your clients trust you and call you, and that you stay up to date on what is and is not an exempt position.
Yeah, and always err on the side of non-exempt. If there's any question in your mind, go to the non-exempt. And also another area that is very closely related to this, that some employers who think that they're really smart do, and that's independent contractors.
Yeah.
But, and what would happen in a situation, and I know this is not the seminar for independent contractors, but some employers will determine that this person is an independent contractor, so they hire them and say, you're an independent contractor, and work them as though they have no responsibility for that employee's conduct or meals. And then that employee complains and gets, and then there's a determination that that person is performing duties that are very close to what the employer does. And so they get determined to be an employee. And when they get that determination, then they're non-exempt.
Yeah.
And so now you got a bunch of meal periods, you got overtime, and all that comes into play. And you have to deal with that, and they can go back as long as they want, the 3 years or 4 years in some cases, and you really got a problem on your hands. So, but the independent contractor versus employee is another area that you should really look into, because a lot of employers get that wrong because they want to save money, or they're trying to be more productive, and some guys say, some people think they're really smart, and then they end up getting, hit with a bunch of fines. Okay, sorry. Just wanted to put that in there.
No, absolutely true, and super important. That's the end of our presentation. Thank you so much, everyone, for hanging out with us. I see we've got 41 people, and it's been an absolute pleasure to be able to present.
Yeah, you have a lot of questions in your Q&A. You need to go there and answer those.
Yeah, I will. I just wanted to say thank you first, and then we'll get to questions.
Oh, okay.
Yeah, I got you. Yeah, just want to say thank you again. And so now we're happy to open the floor to any questions you may have.
Okay, the first question is, I was under the impression that the SOL was 3 years, statute limited 3 years for most wage issues, but you can use unfair competition to go back 4 years. Is that right? And just quickly, I would say, it's 70% right. It's the 4 years goes back if you knowingly did it, not unfair competition. It's if you knowingly work somebody, they can go back 4 years, not 3.
All right. Next question. I just got here. What is it that gets an employee to make a move against the employer initially? Well, it could be a number of things. But the first is, the most easy thing to think of, which is just a general disagreement between management and employees. There's normally a discrepancy on a timesheet, and if the issue isn't resolved to the satisfaction of the employee, they may go talk to a lawyer. Unfortunately, fortunately, because now we have jobs, but California has become such a state that it's so sue heavy that most mistakes that should be resolved quickly end up going to litigation.
Yeah, and no one from the Beverly Hills Bar Association fits into the category of those lawyers that have people go get jobs only to determine whether or not they're complying with all the different orders so they can sue them. But there are some law firms that will have people go and get jobs to determine whether or not they're right for a lawsuit. So that might be one of the, not very many people act like that, but there are some. So that might be a reason that motivates people. Yeah. The next one is, how do collective bargaining agreements impact classifications, or do they?
So a collective bargaining agreement can affect certain wage and hour rights, like overtime and meal periods, only if the CBA meets specific statutory requirements. But if it doesn't, then it does not override the let me actually say this. Either way, the collective bargaining agreement cannot override the requirement to meet California's exemption criteria unless the law provides a clear carve out. But anything short of that, the CBA doesn't have any effect.
Okay, and the last one is interest accrued?
Technically, yes. And I saw this through quite a few cases where interest would be accrued through prejudgment interest. So from the initiation of the lawsuit. So it's not technically interest from the time of issue, but from the time the lawsuit was brought.
Okay, I'm sorry, there's some more, Jar.
Yeah.
If a person works less than 5 hours a shift, do they get overtime and meal breaks?
I'm sorry. I was reading the next one. Sorry. What was it? If a person works less than 5 hours a shift, do they get overtime and meal breaks? So no. If a person works less than 5 hours a shift, they would qualify for a rest break because you get that at your 4th hour. But overtime, you would have to work over 8 hours, and then meal breaks, you would have to work past the 5th hour.
What about 2 5-hour shifts in one day?
So those are that's a great question. So that would be a split shift issue. So let's say you work, 8 to 3 and then 5 to 10. Those shifts are considered independent of one another. So it's as if they're separate days. Yeah, and in order to the workaround that the law has built in is through something called a split shift payment, which is if your workday is interrupted for any significant period of time where you have a morning shift and then an afternoon shift, your employer is required to pay you the equivalent of 1 hour of minimum wage for the inconvenience, essentially.
Right. Under the Fair Labor Standards Act, a willful violation extends to the statute of limitations from 2 years to 3 years, or occurs when an employer either knew or should have showed reckless disregard for whether or not its conduct was prohibited by the FSLA. The 4-year is to extend California Labor Code, not non-1-year penalty violations is under the UCL. So I don't think that's a question, that's a comment.
Thank you. Appreciate that.
Yeah.
And can employers deduct from an exempt employee's leave bank for partial work days? Yes. But there are specific criteria for when that's permissible. It's normally not a good idea, but there are situations where that's permissible. Here, let me show you. Permissible deductions here at the bottom. Only for full day absences, personal reasons, sickness under a bona fide plan, FMLA, CFRA, major safety rule infractions, or legally required withholdings. Does that answer your question? So I don't believe.
We do have some additional questions that we received via email. If you'd like me to read those out for you, is that okay?
Sure, that'd be great.
So with companies shifting to remote work, have you seen that cause any complications with figuring out exempt versus non-exempt classifications, particularly regarding break tracking and managing hours worked?
You want me to answer that? There are situations where it doesn't change exempt to non-exempt or non-exempt to exempt. Where you run into a problem with that is they are still entitled to the meal breaks and rest breaks. And so what we have suggested to our clients is that on timesheets, the employee must indicate that they did actually take their meal break, and they have to sign in and sign out for the meal and rest breaks because they are non-exempt employees. Mm-hmm. Now, if you have an exempt employee, then you don't have to worry about that. But if they're non-exempt, you need to be able to prove that that person took their meal break and their lunch break and any other benefits that go. They have to, you got to show that they clock out at 5, they clock in when they clock in and clock out. And you can have a real issue if you don't do that, because even though remote work is something that came upon us from COVID, it doesn't change the law as it's written in terms of protecting employee rights.
And just to add on to that, so we also had a case where it's a fully remote company based out of Illinois, but staff in California, Texas, Utah, and Nevada. And a practice they had that actually turned out to be really good. So I don't know if we've talked about this, but we're normally on the defense side of most litigation. So we're normally representing employers. This employer's practice was to instruct their staff through a group Teams or whatever chat they were using at the time. Anytime they were going to take a break, they just had to say, they just had to mention it in the actual chat log itself. That came in handy like you would not believe. We were able to eliminate so many claims just because we had a company that implemented a good record-keeping policy. I know it may be different for most remote workers. They may not be keeping a timesheet as good as they should, or companies may not have policies requiring that. But if you have a situation where your team has a remote setup, and they can send their managers a message, no judgment on it, just like, hey, I'll be back in 10 minutes taking a break. Having those records for employers later down the road is amazing.
Yeah, and I just want to comment, there's a comment in here by Seth that says that even on a split shift, if you work more than 8 hours in any one day, that you are entitled to overtime. And I believe that is the law. I think, we may have gotten that wrong, JR, because if you, in any 24-hour period, if you work more than 8 hours, then you're entitled to overtime, even if it's a split shift. It's only, you're not entitled to it if it's less than 8 hours in a day. And then I believe you're also entitled to overtime if you work so many hours within a week. But I mean, the question was the split shift. And I think, we should look at that again, because my understanding was any time you work more than 8 hours in a day, because if you did that, every employer would have people working split shifts, so they didn't have to pay overtime. But thank you for that, Seth. And I'm hoping I'm saying it right, S-E-T-H.
Yeah, well, Seth, I'm going to look into that. But if either way, I appreciate your input.
Yeah. And then one final question, because you guys touched on audits. This attendee is wondering how often they should suggest that their clients audit exempt classifications, and are there any specific red flags that should prompt a deeper review?
Yeah, so I think a great time to perform an audit would be during performance reviews. If performance reviews are given annually, I don't necessarily see that you have to check, assuming that the employee doesn't change positions within the company within the year. I don't think that there may not be a need to, let me rephrase that. It can be helpful, but it is not necessary to have a check more than once a year. Maybe if you do every 6 months, that's being extremely cautious. And it can be something as simple as a questionnaire asking the individual to fill out, describe to me what you do in a day. What tasks do you typically complete? And go through, there's a series of questions that you can ask just to get a feeling for what it is that they do in a day. And can you repeat that last part of the question? I forgot it.
They were wondering if there were any specific red flags that they should be on the lookout for when they're doing these reviews, or audits, I should say.
That's a great question. I think that would vary quite a bit, job by job. There are just so many different things that could happen. But for a red flag when doing audits, I mean, red flag number one, refusal to participate. That can be an issue. And also, Seth, I just saw your question regarding the McDonald's or fast food minimum wage being $20. So we touched on that in the beginning, and that is the minimum. What is it called? The minimum wage requirement is we only look at California's minimum wage policy. Industry-specific minimum wages aren't applicable when we're determining whether determining what the legal threshold is for that this 2025 calculation of like what the salary threshold is. It's just this constant $16.50. We don't go industry specific.
Yeah, and Michelle says that the 4-year is under the UCL. And I think I said that the 4 years, if it's intentional, Michelle says that's not true. It's under the UCL. And that's something that I will look into because that's not my understanding, but I will look into it because she may be correct.
Yeah.
Okay. There is, I just want to make sure we got everybody that was asking a question. And I see, okay, I think.
So that about wraps up Q&A. I have no more questions from the attendees. Thank you both so much for your time this evening. We appreciate you giving this presentation, and I hope our attendees enjoy the rest of their evening.
All right. Thank you so much, everyone. Appreciate your questions.
Thank you. Thank you.
You may be eligible for CLE credit in your state. Visit bhba.org/podcasts for more information.